for the session to kindly grace the dais. Thank you, sirs. The international arbitration has certain benefits as a method of resolving disputes in the international business transactions, but at times it can turn out to be quite costly for the parties. As a result, if third-party financing can be used efficiently and appropriately in the context of arbitrations, it can be advantageous by improving the parties' access to justice and have the impact of leveling the playing fields for the parties throughout the dispute resolution process. This panel shall focus on how third-party funding has often been discussed in the context of litigation in India and shall try to identify arrangements needed under the present arbitration regime for third-party funding to be successful in our country. For the discussion today, we have with us on chair, Honorable Mr. Justice V. Ramasubramanian, Judge, Supreme Court of India. Honorable Justice V. Ramasubramanian was born on 30th June 1958 in Malagudi. After completion of his schooling and LLB, Sir was enrolled as member of Bar on 16 February 1983. On 31st July 2006, Sir was appointed as an additional judge of Madras High Court and became a permanent judge on 9th November 2019. Justice Ramasubramanian was elevated as Chief Justice of Himachal Pradesh High Court on 22nd June 2019 and assumed office as sitting judge of the Honorable Supreme Court of India on 23rd September 2019. Apart from penning various notable judgments, Sir has authored a book in Tamil on the principles of law and justice in Kamba Ramayana. Sir has also written a series of articles under the caption Beyond Science in Tamil newspaper for 27 weeks. I welcome you, sir, in today's discussion. We also have with us as panelists Senior Advocate Mr. Jaideep Gupta. Mr. Gupta is a practicing advocate and has been handling commercial and constitutional litigation for over 30 years in various high courts and Supreme Court of India. He was born in the year 1961 into a family of lawyers in Kolkata. He was designated as senior advocate in the year 2002. Mr. Jaideep Gupta has co-authored the arbitration section of Halsbury Law of India and has also contributed articles to several legal journals. Sir is currently Vice President of the Bar Association of India. Welcome to the discussion, sir. Our next panelist in the session is Mr. Tom Glasgow. Mr. Glasgow is currently the Managing Director and Co-Chief Investment Officer at the Asia Pacific Omni Bridgeway. Sir Tom holds dual degree in law and international relations and is a qualified lawyer in New Zealand and Hong Kong. He is a frequent guest speaker and panelist throughout Asia on topics of dispute funding, litigation, and arbitration. Sir was member of working group that established and launched the Indian Association of Litigation Funders in the year 2021. He assumed a new role in June 2022, covering the wider Asian Pacific region and all international arbitration investments globally. Welcome, sir. The next panelist is Mr. Christian Roth. Mr. Roth is an attorney at law at Paris and Brussels Bar and is a partner at Roth Partners. He has vast experience of more than 20 years in corporate and commercial litigation. Additionally, Mr. Roth has also served as former Secretary General of the Association of European Jurists. He is also a founder and honorary president of the European Lawyers Union. I welcome you, sir, to this session. With this background, I hand over this session to the Honorable Chair.
Mr. Jaideep Gupta, Senior Advocate, Supreme Court. Mr. Tom Glasgow, Mr. Christian Roth, distinguished invitees, dear friends. You must have seen from the invitation that some of the events are said to be powered by some law firms. A couple of years back, we used to say sponsored by. Now we use a very different term, namely powered by. I didn't understand what they mean by powered by. I was told that that event is sponsored by somebody. It means all these sessions have actually started with third-party funding. Therefore, I don't think I have a business to talk something against third-party funding. Any discussion about third-party funding cannot begin without a reference to what was called maintenance and champerty in the common law jurisdictions. Originally, maintenance and champerty were treated as both torts and crimes in common law jurisdictions, but they were held to be not applicable to Indian context. Though there was a division of opinion as to whether such a contract would be opposed to public policy and violative of Section 23 of the Indian Contract Act, the issue was settled by the Privy Council in 1876 in Ram Kumar Kondu versus Chandar Kantu Mukherjee. Today, the world has opened up. Even the Civil Procedure Code amendments which came in 1976 and 1983, has opened up new vistas. For instance, the Civil Procedure Code of 1908 underwent an overhaul in 1976. When it underwent an overhaul in 1976, a particular clause was introduced under Rule 5 of Order 33. Order 33 of the Code of Civil Procedure deals with plaintiffs who can sue as indigent persons. Suppose somebody is not able to pay court fee, he is entitled by law in India to sue as an indigent person, and the court can permit such person to file the suit as an indigent person. But an exception was carved out under Clause G of Rule 5 that an application for permission to sue as indigent person will not be allowed if he is funded by a third party. Therefore, this is the first point at which the law perhaps took a small detour. But I used to wonder, if a third party is funding a litigation, why would a person file an application to sue as an indigent person? Probably after the litigation is over, he may become indigent. That's a different issue. But even before beginning the litigation, I don't think he would become an indigent person. Actually, we are supposed to wind up this session by 11:40. We have a panel of eminent speakers, one of whom is actually representing the largest third-party funder, namely Omni Bridgeway, Mr. Tom Glasgow. So he will perhaps be presenting the point of view of the funder. Mr. Christian Roth is a corporate lawyer. He represents a regulated regime. And Mr. Jaideep Gupta has the advantage of being in a country where we don't know whether we are regulated or unregulated. But anyway, as far as the session is concerned, it will be regulated. Each of the speakers will have 15 minutes. Thereafter, we will throw the session open for an interactive session for about 20 minutes. And then with my concluding remarks by about 5 minutes, we will wind up by 11:40. We are supposed to adjourn to the next hall for the valedictory at 11:40. To begin this discussion, I would like to present a perspective which probably may not be acceptable to all. I was actually worried about presenting this perspective because I am retiring in a period of 4 months. I may be looking forward to some arbitrations. Therefore, I was worried about making this viewpoint. Anyway, I will make this viewpoint. How do we address ethical issues in third-party funding? Suppose somebody is liable, A is liable to get $1 million from B. In an ideal society, he must be able to go to court and get it without spending a single penny, at no cost or at minimum cost. Suppose he is funded by, if we are not living in an ideal society, and he has to spend money to get that money, if somebody pays that money and takes away one portion of it, still he is not getting complete justice because he has to get $1 million, part with $20,000 to get back only $80,000. In case he is able to get, because of third-party funding, $1 million plus $20,000, the other party is not getting complete justice. Therefore, where do we stand is the question with which I would begin this discussion. Now, I'll leave the floor open to the speakers for either for answering or for reserving verdict on this question so that we can next year meet and analyze this. I now call upon Mr. Tom Glasgow to make his presentation. Thank you.
Well, good morning, and thank you to our Honourable Chairman for the introduction, and to the organising committee for inviting me here today. My name is Tom Glasgow. I'm formerly an international arbitration practitioner, qualified in Hong Kong and New Zealand, and I now work at Omni Bridgeway, which is the largest and longest established litigation finance business in the world. I'm responsible for all of our Asian investments and all of our international arbitration investments globally, and what we're looking at doing in India. I've been asked to try and give you an industry perspective on the growth and direction of litigation finance globally, around the world, with a focus on common law jurisdictions. To think about where we are now and perhaps what that means for arbitration in India. And rather than giving generalizations, I think the best way to give you a sense of how the industry has grown is to explain where our business came from, where Omni Bridgeway began, and how it's developed over the years. So Omni Bridgeway is the result of a merger between the two longest established but quite different global litigation funding companies. The first originated out of the Netherlands in the 1980s and built its business by funding the enforcement of unpaid debts, judgments and awards. It developed expertise to create and fund multi-jurisdictional enforcement strategies for clients in exchange for a share of what was recovered. That business then began predetermination claims funding as well, primarily in civil law jurisdictions across Europe and the Middle East, where the ancient torts of maintenance and champity didn't exist. The other side of the business began in Australia in the 1990s, establishing a fund which it used to support liquidators of insolvent companies in the recovery of claims against third parties. That business grew exponentially on the back of Australian case law, including the senior court's decision in Foster, which established that the funding of litigation of itself is not champitous under the Australian common law. And indeed, similar pronouncements have been made in courts throughout the common law world, including in England and Wales, Singapore, and Hong Kong. The focus of the Australian business started with insolvency-related claims and developed to support general, commercial, corporate claims and mass group actions. The business listed on the public stock exchange in 2001 and started to grow into other markets from there, on the back of strong demand into the UK, the US, and Canada. About 6 years ago, we moved into Singapore and Hong Kong on the back of specific legislation and guidance brought in to facilitate the funding of arbitration and international arbitration. And the pace of growth has not slowed. we are now a truly global business. We have offices spanning Australasia, Asia, the Middle East, Europe, the UK, the US, and Canada, from which we service almost the entire world, including LATAM, Africa, and of course India. And it's my hope to put a dot on the map here for India in the near future. This map here shows in gold where we have funded parties or cases or enforcement actions. And as you can see, there is very little of the globe where we have not been active. And as our geographic footprint has developed, as has the demand for our financial services, we now have approximately $3 billion in funds under management, deployed or for deployment into litigation funding opportunities, and we expect to be committing at least $1 billion each year into new investments in the near future. So that is what our business looks like, and that's indicative of the growth of the industry as a whole globally. But what is it that we actually do? Well, we fund strong claims and defences only, and we fund them in exchange for a share of any commercial benefit if the claim is successful. If the case is unsuccessful, we wear the cost, and potentially the adverse cost as well, and we have no other recourse against the funded party. In some instances, we not only fund the costs of the case, but we monetize the contingent value in the dispute, allowing parties to bring forward that value and improve cash flow. We are incredibly selective in the investments that we choose. On average, we fund 1 in 20 cases shown to us. Each case must be strong on the merits, economically sound, and with strong prospects of actual recovery. Our due diligence goes very deep. We front-load the issues in dispute, we assess the evidence, we assess the witnesses, we quantify damages, we establish the likely costs at the outset, amongst numerous other risk variables. An investment proposal is then vetted by our investment committee, which consists of retired judges, sitting arbitrators, damages experts, and senior counsel. So as such, a claim funded by Omni has likely received far more detailed review and assessment than any other unfunded claim. And any suggestion that our funding creates more claims just doesn't reflect reality. If anything, our critical review is more likely to dissuade parties with unmeritorious cases. Now, as you can imagine, we are very active in the international arbitration space, where costs are very high and ever increasing. But by far and away, the most notable trend in our industry is a shift away from our funding being used only by impecunious parties to its adoption as a sophisticated corporate finance and risk management tool. Our clients are now predominantly well-resourced MNCs and sophisticated corporate parties, seeking to manage the risk and the cost associated with their complex disputes, or to monetize the contingent value in their arbitration assets. And it's perhaps obvious why an impecunious party would seek out funding, but less obvious why well-resourced parties tend to do so. And there's many reasons for that, but I'll just highlight a few. First of all, as I said, the costs of arbitration are ever increasing, but the cost to a business can be far more than just the legal costs. There is a massive opportunity cost in diverting capital away from one's core business to pay for arbitration, foregoing projects and the profit that comes with it. So our funding allows a business to pursue its legal rights and pursue its core business at the same time. Secondly, our funding is non-recourse. So we only receive a return on our investment if the case is successful. If we lose, we wear the cost, we cover the adverse cost. But for the corporate party, that means complete downside risk management. Thirdly, and also because our funding is non-recourse, the funded party has no corresponding liability on its balance sheet for the funding that we provide. And this is a unique and very appealing situation for CFOs, for financial controllers, who say, I have no drag on P&L, no liability on the balance sheet, no downside risk, and retain only significant upside in the dispute. And lastly, there are important non-financial factors as well. We bring expertise and insights, especially in the development of multi-jurisdictional enforcement strategies, which a traditional financier can't bring. Then there is the messaging to stakeholders. The business can point to a stamp of approval from Omni, which has an 80% success rate, and demonstrate that they have mitigated risk. And this might be particularly important to a business that's seeking to attract new investment or keep shareholders happy. Then there is the messaging to an opponent, that you've levelled the playing field, that you have a strong case and you have the funds to pursue it. And these factors, among others, are really what's driving sophisticated corporates to seek us out, and that includes many businesses in India. We are and that increasing sophistication of our clients is causing us to increase the sophistication of the financial products that we offer. So we are frequently now funding clients with multiple cases in a cross-collateralized portfolio. And this allows clients to access funding for a broader set of cases, including lower value claims, claims for declaratory or injunctive relief, or even defences. We are also frequently providing an advance on the claim value to be used as working capital. And that advance is provided on the same non-recourse basis, which means that, again, there's no corresponding liability on the balance sheet. So companies are free to use that capital as they wish, or to declare it as cash or profit. Again, a significant and unique feature of our financial products. So hopefully that's giving you a sense of what we do, and perhaps that's broader than you might have imagined it, and gives you a sense of how the industry is developing and its sophistication. And in the future, I can really only see more mainstreaming of our industry as awareness grows around the world and potentially here in India. Certainly in the last 10 years, we've seen an increase in demand from investors for exposure to this asset class, and we've seen an increase in competition from new litigation funds. That said, this is an incredibly difficult business to succeed in. Litigation is extremely complex. Arbitration, I would say, is even more so, and one has to be very selective. And that's not always been the case amongst our competitors and some of the new entrants to this industry. So on the back of that, I am actually predicting a period of consolidation in the coming years, as those that have overextended themselves will inevitably fail. And in that way, this is an interesting and self-regulating business. Very hard to succeed and easy to fail. So it's probably time for me to address the question, how ready are we? Well, the industry is certainly ready, and there is significant demand from what we do from the corporate world, and in international arbitration in particular. And this includes India. Of all of the countries across Asia, we see the most funding applications from India, about one every 2 weeks. Places like Singapore and Hong Kong have taken legislative action to facilitate the funding of arbitration in support of their position as leading global hubs for arbitration, and because of prior uncertainty in their laws. In other countries like the UK and Australia, the judiciary has been very proactive and positive in addressing any uncertainties. And the same might help in India, and I would welcome an opportunity to engage on this with relevant stakeholders. We are not averse to appropriate regulation or guidance, but what we do seek is clarity. And in the meantime, we are working hard with other stakeholders, including a lot of people in this room, to engage with users of arbitration and to bring best practice and understanding around what we do. Overall, I believe there's enormous value that we can add to the arbitration ecosystem in India, and I look forward to seeing how this develops here. Thank you very much.
Thank you, Tom. Thank you for presenting an insight into the way the litigation funders function. May now call upon Mr. Christian Roth. He's a corporate lawyer. He is accompanied by his spouse, the better half, who is the third-party funder for him.
Yes, Honorable Ramasubramanian, thank you for, thank you for these nice presentation words, indeed. Thank you for the organizers of this event, and especially Mrs. Justice Rika Pali, who has been the marvelous overall organizer and caretaker of everybody here in this conference. It is a delight. And I must confess that although it is a delight, I am since 3 days in a sort of total confusion. Because as you heard, I'm a French attorney. And we come not from a common law culture, we are from a civil law culture. And we strongly advertise and want to, let's say, step away from the overall common law attitude of laissez-faire, which sometimes brings us in uncertainties. And this is why listening to all the debates here, it is very interesting to know how, or to understand and to feel how, most probably in the Indian jurisdiction, you are still looking what is good, what is not so good, from this inheritance of the former British colonial might that was upon you in the legal practice. I expressed it the other day by intervening in one of the sessions. I was terribly confused about what I heard here in this country about the need for arbitration. Arbitration that, for me, as a litigation practitioner over now the 40 years, arbitration was always the big thing only for very big law firms and very high seasoned lawyers about multi-million-dollar disputes between an American company, a Chinese company, a Japanese company, etc., with an arbitration choosing Swiss law and taking place in another exotic place of the world. Now here, listening to what you mean here under arbitration, I discovered that arbitration is a way of settling disputes, of alternative dispute resolution, due mainly to a structural, let's say, difficulty of the judiciary to come up with the flow of cases that you have here in the commercial field. And I was giving the example of France, where, contrary to the common law world, we have a network in the whole country of commercial courts specifically specialized in dealing with commercial settlements. And these courts are, the judges in these courts are elected. They are not from the judiciary, so to speak of. They are elected by the Chamber of Commerce, and they are on a tenure of 4 years that is renewable 3 times. And they are not professional lawyers. I mean, they are not trained as lawyers. They come from the industry. And you can have a banker, a hotel manager, an in-house counsel who, for 1 day a week, comes and sits as a commercial court judge. And this, of course, relieves a lot the pressure of commercial settlements on the, let's say, ordinary judiciary. So, having this in mind, now I wanted to have the approach of introducing you in what we have today as our topic of the day, which for me, when we talk about third-party funding, it is basically in a much larger thinking pattern of how do you facilitate access to justice. Because here we have been talking about arbitration for 3 days, but actually somewhere we're dealing with the need for the general population to have access to justice. And since we have evolved from the Middle Ages to the modern ages and to the Enlightenment, everyone has the right to have an access to justice. Now, in all legal democratic states, of course, the access of justice is guaranteed through legal aid, of course. But what happens if you are not eligible to legal aid and you are involved in a case that is where you are not eligible for legal aid, but where you have an opponent who is monetarily much more, funded than you are? So it is interesting to see that means of finances have emerged over the years, especially in countries like common law countries, but also civil law countries like Germany, where the trend has been very successful but that is also a consequence of it, due to the fact that the court costs and the court fees and the lawyers' fees are regulated by law. So there is very typically a risk analysis that can be done at a very early stage. If I fund you, how much am I going to see that I can retrieve as a profit from having funded you? Over the years, in the field of European law, we started to regulate, and I'm going to give you here a presentation of what is now the positive existing legal situation within the European Union. When I say European Union, is the union of 27 members. We don't have the United Kingdom anymore as a member of the European Union. So this presentation will apply to the mostly the countries of the European continent. And here, the first idea was that the Commission, which is our administrative body that is managing the affairs of the European Union, recommended that there should be some guarantees, that there should be guarantees for the use of third-party funding to injunctive and compensatory class actions. From there, from this recommendation, we moved to a directive. A directive, I have to explain to those who are not familiar with European law legislation. The directive is a law that is passed that applies to all of the 27 countries at once. But it has to be implemented in the national law of every country. So it is like a federal regulation that directs the 27 countries. The directive, which was adopted in 2020, was, and it is not even implemented yet. The deadline is June of 2023. This directive was meant to provide and to allow third-party funding for redress actions in the field of class actions. But, again, class actions with the normal judiciary system, that is, going to a court. And now we come to the topic of our conference today, and in general of the conference that we have over the last 3 days. I just said the directive was talking about allowing third-party funding or regulating third-party funding in class actions within the frame of court actions. And now, here I will present you now the tendencies that will probably emerge. We are at a very early stadium. This is a European Parliament resolution in view of a future directive, meaning that for the moment it is a proposal that will eventually become effective once a directive has been adopted. And here, what is interesting and important to notice is that this proposal of a directive will deal exclusively with third-party funding within arbitration. So you see, third-party funding, class actions, court system, and now third-party funding, arbitration. And this directive will go in depth in many solutions that could be implemented. And the main focus, of course, is, the main aspect, the main concern is the respect of the principle of transparency. I will show you what it means. Sorry. So this is just to give you an overview on how the legislative work, how that works between the commission who makes the proposal goes to the parliament then debates it with the council, and there is a joint adoption of a directive or of a regulation. For those who are not familiar with European law, it is one of the most incredible instruments of integration where when you have one regulation, this is a regulation, that is a law, it applies to a Swedish person, it applies to an Italian person, it applies to a Belgian, to a French, and it's over all the European Union. So here we will now go through the different aspects of this draft directive. The first important thing is that the directive is focusing on transparency requirements. The transparency requirements come from the following idea. As Tom explained, well, a party that has sought for funding of course, will be very happy to have gotten the funding. But in an arbitration, as well as in a court procedure, there is also a very known rule for all practitioners of the equality, the equal position of the parties in front of the judge and in front of the arbitrator. And this equal positioning, the equality of the potential that you have in a law case and in a lawsuit has to be guaranteed by the knowledge of how strong the one or the other party is. And this is why the principle of transparency is imposed because the opponent party must exactly know how much can I expect from the other party to be resilient in a law procedure. And because until now, and I have to contradict a little bit Tom on that, the fact that one party had been funded is often, or was in the past at least, not disclosed or not public. And therefore, you could have a court case or an arbitration case with the party being, well, very adamant in aggressive techniques with a strong litigation team, etc., but without, in fact, indicating where this strength came from. And this is how the thoughts came up with the European Parliament and generally also the bodies of the arbitration institution, and I will come to that very, very quickly, is that the third-party funding agreement, which is the base of the contract concluded between the party and the party funder, Omni Bridge, for instance, this agreement, if it exists, should be disclosed during the arbitration process. I see you are not agreeing to it, but this is exactly where we will come with the European directive. And this is what is going to wait for you in the future, and we can have a very interesting debate on that. I will give you a few examples on how this is starting to show everywhere. At the European level, there will be this absolute requirement of disclosing the third-party funding agreement. And at the extra-European, now we are outside of the sphere of the continental Europe, and I wanted to check how far the ideas were permeating also other jurisdictions. In Singapore, the SIAC investment rules, Article 24, have already included in their rules that, Article 24, the tribunal shall have the power to order the disclosure of the existence of a party's third-party funding arrangement and or the identity of the third-party funding and, where appropriate, details of the third-party funder's interest in the outcome of the proceedings. Hong Kong has also adopted something similar. And ICSID, of course, also a party shall file a written notice disclosing the name and address of any non-party from which the party blah, 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 has received funds. So I'm going short on that because also in France, the Centre d'Arbitrage International de Paris, as well as the ICC, the International Chamber of Commerce, have adopted similar rules or have integrated similar provisions in their rules. Not like here, not yet. In the Delhi International Arbitration Center rules, I have not noticed anything about third-party funding nor disclosure of third-party funding agreement. But maybe my colleague Gupta will speak about this later. So, what are the consequences? I wanted to review very briefly the consequences of non-compliance with the principle of transparency. Because, of course, it is very nice to say, if there is a third-party funder, please disclose it. And please show me the agreement. And what happens if, first, he doesn't disclose, and second, he doesn't show the agreement? What happens? What are actually the consequences of not disclosing? What are the means, the sanctions that could be imposed? So we have here a number of suggestions from in the draft directive. I warn you, it's not yet applicable legislation. It is a draft directive. It will be discussed, probably. So here, supervisory authorities, so that indicates again that the state regulation will be introduced, should be empowered to make any necessary orders, including the power to receive from litigation funders application for authorization, to gather any necessary information, grant, deny, suspend, or withdraw any authorization. So that could lead to a denial of continuing an activity of third-party funder. Yeah. So I'm going, I just would like to give you, because then we will go to the most dire consequences. What is, in fact, the most interesting here to find out in a third-party agreement? And that is something that is not in the field of our thinking here, but it needs to go in the field of morality about the conduct of a litigation. The biggest critique that has been made to the third-party funding system is that there was no transparency. And why no transparency? Tom addressed it briefly, but he said the risk analysis allows his company to invest, to bring the funds to a strong case. He didn't mention the weak cases. And second, he said the interest for OmniBridge is to have a share of the proceeds. Now, I hope that his company has a fair approach of what means the share. But the problem is, and this is why the regulator has been intervening, is that on the market, it could be observed that the shares sometimes were going from 20% up to 60% of the proceeds. And then you see that, in fact, the party funding, the third-party funding, is a real financial investment issue that is not anymore in the interest of the litigator himself. And that is why, on our level, within our jurisdiction, European jurisdiction, we are going to tend to a regulated world, yeah, exactly, to a regulated world where, after having been told twice to be a little bit briefer, we want to introduce something that is necessary. Clearly, party funding is necessary, but it should not be the free-for-all system. Thank you so much.
Thank you, Mr. Roth. We are very sorry for the interruption. Anyway, we couldn't avoid it. You only said any beneficiary beyond 60% is illegal. Therefore, we didn't want you to have more than 50% of the total time. That was the reason for we applied the law first to you. May I now call upon Mr. Jaideep Gupta to make his presentation.
Thank you very much, Justice Ramasubramanian, for your kind introductions to all of us. I have an easy task and a difficult task because we don't have a framework of regulation. We almost do not have a law on the subject in this country. So my job was to hunt around and see what I could find at least is established so far. So the first question that an Indian jurist would have to address is whether a third-party funding agreement is at all legal in India. Now, an agreement to finance another person's litigation in return for a share of the proceeds without having a genuine or substantial interest in the outcome of that litigation was, up to a point of time, under English law, which we adopted at some stage, illegal on the basis that it was champotous and amounted to maintenance. I don't have to get into the details of that, because I find that we perhaps have moved away from it to some extent. Now, at the time when it was adopted, the English law was based on its own criminal and tort statutes, which did not apply to India, and so therefore, in the 19th century decisions, it was stated that these principles would not be applicable in the Indian context. But another principle was applicable in the Indian context, as it was in common law jurisdictions, and that was the concept of public policy, and whether a particular agreement or a contract was contrary to public policy. And under this head, this kind of agreement came to grief in many situations. The second aspect is that at common law, an agreement between a client and legal advisor for the payment of a contingency fee or a conditional fee, which depended upon the outcome of the litigation, used to amount to champotty in England and was therefore illegal. But since 1990, statutorily, those restrictions have been removed. Of course, those statutes do not apply to us in 1990, so therefore no benefit flows to our jurisdiction from those changes. Section 23 of the Indian Contract Act, which declares that the consideration or objects of an agreement are lawful unless it is forbidden by law or the court regards it as opposed to public policy, is the head under which we would in this country analyze such laws or such agreements. Champotty has been held to be against good public policy and justice because it tends to promote unnecessary litigation. This is an old Indian case in G.F. Fisher versus Kamala Nayakar. Tom mentioned that this is not something which can be alleged against modern third-party funding, and of course that may require to be gone into in some proceedings. What we find is that from 1874 onwards, it is not per se illegal to fund a litigation. And I don't blame the Honorable Chairman for struggling with the name of that case, because it is a complicated Bengali name, made more complicated by the fact that Bengalis of that time preferred to somehow twist it into an European or an English format. So what is Ram Kumar Kundu versus Chandrakanto Mukherjee, fairly easy to understand for anybody who understands Hindi or Sanskrit, became Ram Kumar Kundu versus Chandrakanto Mukherjee.
But if you search in the Google with the right name, you will not find it.
You won't, because this was the problem. And just by way of aside, in places like Chandannagar and Pondicherry, which were under French influence, they tended to twist the Indian name into the French mode. So Mr. Rakshit became Rekit. Anyway, to get on with this current topic. So therefore, it is clear in our jurisdiction from the very beginning that an agreement which is strictly speaking champotous according to English law was not necessarily void in India unless it was shown to be against public policy. For this, we have the case of Raja Rajdayal Singh versus Devi Dayal Sahu in 1860. a present transfer of property for consideration by a person who claims it against another who is in possession thereof, but who has not yet established his title thereto, is not contrary to public policy according to Indian case law. Similarly, an agreement to share the subject of the litigation, if recoverable in consideration of supply of funds to carry it on, that is to carry on the litigation, and not in themselves, are opposed to public policy. These are judgments also of 1800s, Raghunath and Neelkant, Inder Singh versus Munshi, etc., etc. So therefore, what is interesting is that it has never been per se illegal to fund litigation in India. An advance made for litigation with a claim for refund of only what has been advanced and not for the property recovered in litigation is also not contrary to public policy, for which we have a 1954 Hyderabad judgment in Dara Shukurji. However, in Ramkumar Kundu, while saying that it is not per se illegal to finance litigation, the following caution was indicated. It was said that a fair agreement to supply funds to carry on a suit in consideration of having a share of the property, if recovered, was not to be regarded as being per se opposed to public policy, but agreements of this kind ought to be carefully watched, and when found to be extortionate and unreasonable, so as to be inequitable against the party, and it is not made with bona fide objects or improper objects, such as for the purpose of gambling in litigation or to cause injury and oppression to others, in that event, effect cannot be given to it. Now this has two effects. One is, though it is not per se illegal, it is illegal if it is extortionate. Now that means that this question has to be decided on a case-by-case basis, based on the agreement concerned and the facts of that case. Now, I don't believe that third-party funding of arbitration can proceed if each time it was found to have been taken, it was open to the courts to litigate on whether it was a valid contract or an invalid contract, because I am sure that is not the kind of risk that a third-party financier would like to take. Now we come to a development which is fairly recent, in the sense that the Honorable Supreme Court has taken a stand on it. This is the judgment in Bar Association of India versus A.K. Balaji, which is a 2018 judgment, where the Supreme Court of India has stated that there appears to be no restriction, the words are like that, appears to be no restriction on third parties, within bracket non-lawyers, funding the litigation and getting repaid after the outcome of the litigation. But it has been held that while the funding of litigation by lawyers is not expressly prohibited, the rules of ethics which are codified by the Bar Council of India, and particularly three rules. One is Rule 18, which is against a lawyer fomenting litigation, causing litigation. Rule 20, which prohibits contingency fees, and Rule 21, which prohibits share or interest in an actionable claim, would strongly suggest, according to the Supreme Court, that advocates in India or lawyers in India cannot fund litigation on behalf of their clients. Now, while this appears to be a very comprehensive statement, it must be noted that these observations are in a judgment which had nothing to do with third-party funding at all. The judgment was in relation to the extent to which foreign law firms could practice in India. And in that context, this observation appears to be completely arbiter and does not seem to have any relationship with the rest of the judgment. However, in our country, even an observation of that nature is binding unless it is set aside by the Supreme Court. So, we can for the time being proceed on this basis that non-lawyers can fund litigation. Please note, however, that this does not take away Section 23 of the Contract Act. It does not take away the old case law which says that it has to be checked in each case whether public policy prohibits that particular contract. It's a question of fact. Again, that won't be a very advantageous situation for third-party funding. The next thing we note is that almost by the side wind, the Civil Procedure Code has acknowledged the existence of third-party funding in India. One example was given by Justice Ramasubramanian in Order 33. An even more direct one I find in Order 25, which was amended by 3 states, Maharashtra, Karnataka, Gujarat, and then Madhya Pradesh, to say that security for costs can be given by a third party if there is a third party involved. Now it says nothing about whether third parties are allowed to be involved or not, but it says that assuming that a third party is involved, the court can ask for security of costs from the third party. Now again, it is not a direct answer to the question at all. And what is more, this security for costs, though it has been available in our statute books for decades, if not more, for a century, it is now hardly in use. We hardly ever find an order whereby the court directs the plaintiff who has begun the cause to put in, by way of security, money which will cover the costs of the litigation for the other side. It doesn't happen very much here. And in this context, it is said that if a third party is funding, then he can be asked to put in. But you can see that some amount of comment on this proposition is to be found in these amendments. Where does this leave us on the question of whether it is legal or not? All this is suggesting that it is not safe to go for third-party funding until and unless we either have legislative regulation or we have at least adopted model agreements based on international best practices, and that has become either part of the proceedings or have been signed by the parties, without which the third-party funder is in danger of that award being challenged in a court of law on the ground of championship and maintenance after the entire process is over. There was one such incident in recent times in Hyderabad, but it seems that the matter never reached any conclusion because it was withdrawn before the question was gone into. But the ground was taken that there was third-party funding, that is championship, and so therefore this entire process is vitiated. Now, because of this, in the absence of any regulation for the promotion of third-party funding in India, several of the concerns which are ancillary to this naturally also remain unanswered. I will just give you 2 examples today because I don't want to go on into the entire topic. One is, as Mr. Roth had indicated, what is the position as far as disclosing the existence and name of the third-party financer is concerned. Now, where this comes into the Indian legal framework is that we follow the ancestral model law in our Arbitration Act. The Arbitration Act makes it clear that an arbitrator has to disclose his interest, if any, in the litigation or in the parties. Now, it has been strengthened even further by putting a schedule into the Arbitration Act which lists a number of situations where the arbitrator should disclose an interest. Now, the third-party funding creates this problem if it is not disclosed. The arbitrator may have some interest in the third-party financier, but if the other side does not know that, then it will not be disclosed. And so therefore, as my friend Mr. Roth said, equality will be disturbed. One party is going blindly into a situation where he doesn't know what the other party is really doing. This is the reason why it is necessary to have some protection in this regard if you are going for third-party funding in the Indian context. If you do not disclose, then this cannot be done. If you disclose, then Tom's greater worry of party autonomy being affected, which is, I think, the reason why there was a disagreement on this issue between Mr. Roth and Tom, is that Tom's system of jurisprudence believes in a high regard for party autonomy, and so therefore they are not comfortable with the idea of disclosing necessarily that there is a third-party financier, and certainly not disclosing the elements of that agreement. Now, we have seen that there are, internationally, there are different approaches being adopted. Some, like UK, do not require disclosure, but they might have to disclose if the arbitrator directs. But the arbitrator will not direct unless the party applying for it has some reason to think there is third-party funding. He may say that we can't just assume that there is third-party funding. Only if you show me some prima facie evidence that there is third-party funding, I will give you such a direction. But in the absence of disclosure, what prima facie evidence can be given by a party for disclosure of third-party financier? Now, this is one aspect. The second aspect is the question of transparency, and I will just very shortly put this because my slip has also come. When you have a third-party financier, the facts of the case are disclosed not only to the arbitrator and to the other party, but also to a third party. Now, that is against many rules of transparency in arbitration. And what we have in India now is a very a situation where Section 29 capital A has been added, which says that there is a duty of confidentiality on the arbitrator, the arbitral institution, and the parties. Now, this might either mean that this is not exhaustive. You can, by way of non-disclosure agreements, include third-party financiers. Or it could mean that it is exhaustive, in which case there is no such disclosure requirement as far as third-party financiers are concerned. One last sentence before the second slip comes along. There is a question of practicability in India. It is my understanding that third-party financiers use some model to come to a conclusion as to whether this is an investment that they would like to make or not. Sometimes this is artificial intelligence. They use models, algorithms also. Tom will be able to tell us more in the question answer, if possible. But that requires reasonable certainty of all the factors which they take into consideration. Now, in the Indian context, there is one simple factor which is almost completely impossible to predict, and that is the length of the proceedings. The length of the proceedings, if it is not possible to predict, that very critical ingredient which goes into the decision of a third-party financier is not available. So therefore, is it at all practicable? You can see that where I'm headed, I don't think we are ready. In order to become ready, we need either regulation by way of legislation, or we need best practices being adopted by arbitral institutions, and much more discussion in any public forum like this for the purpose of coming to an understanding as to what it involves. There are myriads of problems. All those have to be separately discussed. Thank you very much.
Thank you, Mr. Jaideep Gupta. In fact, when he said that there is one factor in the Indian context which, which provides a great deal of uncertainty, I almost had a heart attack because I thought he was going to point out judges. Fortunately, he said length of the proceedings, so we are saved. Now that leaves us actually, we are at 11:31. We can take 2-3 questions, but please mind, we can only take questions, not opinions. Yes. Yes, yes, yes. You have a... It will be better if, see, I have been accustomed only to asking questions, not answering questions. So better to address these questions to the panelists because they are experts.
No, my question is for Tom.
Yes.
What are the parameters you use to assess the merit of a case? Because my thinking is that unless you know the other side of the story, how would you be able to assess the merit of the case on a firm ground? Then it almost ends up like a best judgment guess. So I would like you to enlighten us on that, please.
Can you hear me? Yeah. It depends on the case and the stage at which the case is at. So we sometimes will get involved before proceedings are filed, in which case we are critically assessing the claim as it's presented to us, trying to anticipate what defences might be raised. We look very carefully at the documentary evidence. We sometimes interview witnesses and want to understand what they're going to say. Of course, we look in detail at the legal arguments that the lawyers are presenting. And we ask the lawyers that we're working with to think about it objectively. You know, what are the defences that are going to be raised here? Where are the weak points potentially in the case? So that we can challenge that and understand that. Of course, if we're coming in at a later stage when pleadings have been filed, defence has been filed, maybe evidence is there, then we can more critically assess the situation. Whilst I've got the mic, can I make one comment about disclosure of our interest in international arbitration, because I'm not sure our position at least was correctly understood. We will tend to ask a claimant to disclose our involvement at the beginning of any case that we're involved in. So in the request for arbitration, it will say that the claimant has funding from Omni Bridgeway. It will say who we are, direct them to our website, our address, and so on. Because we are equally concerned about the conflict issues. If we fund a case and get an award and it's set aside because there's a conflict, then that's not in our interest. So we're very transparent. Not every funder is, but what is the growing trend in international practice is for tribunals just to ask the question. At the beginning of the proceedings, is anybody funded? And that might be the claimant or the defendant. If you think about defendants are often funded by their insurers. And there's potential for an arbitrator to have a conflict of interest with an insurer that stands behind a defendant as well. So that's the growing practice of tribunals internationally. I think that's the simplest way to fix that issue.
Thank you. One more? Yeah.
Thank you so much for the session. I do have a question with regards to the access of justice and third-party funding. While I understand how Mr. Tom has mentioned that there is a risk analyst who is, seeing the situation, and Mr. Roth also mentioned about the EU directive about the access of justice for the weaker party. While I understand that it works better in fine print, but I need to understand how it works in practicality, because risk analysis would also mean that you are analyzing the parties and their claims and also the chances of them for winning the case, because you said if the parties do not win, you do not get the money. So if somebody is analyzing and seeing that the party might have a slimmer chances of winning the case, does that mean the party should not get the funding? Won't that compromise with access to justice in that case, because the parties have a slim chance of winning, so they're not getting the funding, and thereby not a proper access to trial, free trial?
No, the issue is the funder is not concerned with the justice to the party. Yeah. It is the parties to the litigation who are concerned about who gets justice. The funder is concerned about whether a party who has got a good chance of succeeding in a case will not succeed because of lack of funds, lack of expertise, that's all. You want it? Yes.
What are the key challenges that funders like you face when, say, you fund a case which is seated in India, or where the enforcement of an award has to happen in India? And what can we as the arbitration community or the various other stakeholders can do to iron out those challenges?
Thank you. To be clear, our involvement in India to date has been in supporting Indian parties that are involved in international cases outside of India and potential litigation in the US and the UK. But we are actively looking at the domestic market here and the domestic arbitration market, trying to understand that and whether there is an opportunity for us to support claimants here. I think Mr. Gupta touched on our key concern, which is really around duration. The length of time it takes to get not only through the arbitration proceedings, but to recovery on an award. We have to deliver a return to our investors. The longer things take, the more that return is essentially eroded. And so it makes potentially difficult economic analysis for us to be effective in the Indian market. But there might be ways to deal with that. It might be that we would get involved at a later stage perhaps we're coming in to help monetize an award that's already been obtained while the claimant is waiting to go through the process to enforce that award. But going through the full length, pre-claim to recovery in proceedings in India might be problematic.
All right, my one more question. Yeah, that's right.
My question to Gupta, considering the Indian context, when we are talking about the third-party funding, say it in the litigation, say it in the arbitration, the ethical or moral component, are the Indian litigators, are the parties to the arbitration, to be ready for that and not think that the morality or ethical component will come, and then again the funding, the funders also in India.
Since we are talking more about arbitration, I think arbitration is a very commercial decision. So perhaps the morality and ethics of it will really be relevant more for individuals in litigation than for commercial arbitration.
Commerce and morality, we don't think it's an oxymoron.
Which is why Tom told us that the growing sector is of very large corporations who certainly do not have any financial constraints to use it as a risk management tool. So you see, arbitration often has to be looked upon as part of a business, part of the business of the corporate entity in the first instance. So perhaps that would not, it may not come in the way. If you wish to have your dispute settled through third-party funding, this won't come in the way, perhaps.
Thank you. Mr. Roth would like to say something. Yeah, it's on. It's switched on.
It's switched on. It's switched on.
Yes.
Yeah? Okay. Now I just wanted to share the German experience, because I'm very much involved in cross-border litigation with Germany. Germany was one of the prime markets for one of the prime markets for third-party funding, and I think Tom's company was present on the German market very early on. Why? Because the German market is a super regulated market. You have judicial predictability. You lodge a claim, you know exactly 6 months later you have the judgment. And you go in appeal, you have already an indication when the appeal sentence will be rendered. You know exactly the fees that you will have to support when it comes to the fees of the opposite party. And you know exactly the cost of your own lawyer, because all this is law regulated. And therefore, the German jurisdiction for legal matters, I'm talking of court matters, is ideal. And I think they rank 1 in the catalog of the, it's the Shanghai test. Yes, cooperation organization, that showing that the predictability is perfect in that market. And then that's where a third-party funder can be very much present on that market because of, well, there is almost no risk, but there is a need, of course, for a number of litigators who are of not so favorable monetary means, but in a market that is working really like a Swiss clock. Okay.
That brings us to the end of the session. I actually need to sum up, but I don't think we have time. Only 2 or 3 quick questions. One is, what about party autonomy? How far party autonomy is influenced by litigation funding? Suppose in the course of the proceedings, a party wants to settle a dispute. He can't settle it unless he has the sanction of the funder, number 1. Number 2, what happens if there is a litigation between the funder and the funded after the proceeds come? In fact, the earliest case that we talked about today, Ram Kumar or whatever, Ram Kumar Kundu's case, that was a litigation between the funder and the funded. The lawyer himself bought the property, and that was the case. So what happens then is another question. Then, this, I don't know, BCCI versus AK Balaji, Mr. Jaideep Gupta mentioned that the non-lawyers are prevented from
entering into such funding agreements. But the non-lawyers, financiers, on their behalf can do it, because ultimately the funding is for the benefit of the lawyers. Therefore, why should the lawyers fund it? That is perhaps the reason why we don't have. And Order 25, about whom Mr. Jaideep Gupta talked, it actually enables the third-party funder to be impleaded as a party to the proceedings. So he becomes a litigant by himself. Therefore, I don't know whether he would need another funder to fund it. With these few words, we wind up this session. I thank very much the panelists for an exciting session. Thank you.
I thank the Honorable Chair and the panelists for giving us such an engrossing session. Thank you, sirs. I request all the dignitaries and our esteemed guests to kindly join us for the closing ceremony at the auditorium.